Okay, so very good afternoon, evening, morning to all the academic learners, those who have joined for this academic counseling for the subject business law. I have started the recording, so you can write your attendance, that is your names, in the chat box, and that is going to be recorded and marked as your attendance for this academic counseling. I hope everyone is keeping good.
Yes, ma'am. Thank you.
So, as discussed in our last academic counseling, that was yesterday, I have already informed you that for the subject business law, there are 6 blocks, and today we are going to talk about the second block, which is in 2 units, that is the Companies Act of 2013 and the Partnership Act of 1932. So, very quickly, as informed to all of you yesterday, that we are going to divide the time in such manner that we can have for like both the acts some discussion, and then after that we are open for any kind of queries or concerns if you have. So, wherever you feel that you have any question to ask, you can write that in the chat box. And by the end of the entire academic counseling, I'm going to address those questions. I hope all of us are on the same page. Shall we begin?
Yes, ma'am. Yes, ma'am. Yes, ma'am.
Okay. So I'll quickly share my screen with you so that you can see the content. It is already there, which is available on eGyankosh. We'll start with the Partnership Act of 1932. The screen is now visible to everyone. Let me quickly brief you about that. What are we going to cover in this particular Act of 1932? We are going to talk about introduction to what basically partnership is, definition, essentials, types. We will be also talking about major and minor partners, different types of partnership, and how it is different from other forms of organization. Further, we are going to talk about the formation and registration of partnership. So, what is partnership deed and what is the effect if you do not go for registration? That is effect of non-registration. As all of you, would be surprised to know that there is no compulsion on the partners to get the firm registered. They can make an agreement and they can start with the business, but it is advisable that if they go for registration, it is always an evidence or an onus to prove, which is always going to help them in any case of future challenges if they have in the organization. Then what we'll be talking about is what are the rights and duties of partners, what are the rights, or rather I would say the authority of a partner as agents. When there is any kind of a reconstitution done, that means you are admitting, retiring, or expelling or death of the partner. So what are the laws related to it? And finally, we will be talking about dissolution. That is if when the firm comes to an end. So that is all what is about your Partnership Act of 1932. LLP in itself is, as I've discussed with you yesterday also, it's a blend of company and partnership. But LLP is more towards giving a security to the partners. So in 2008, there was an act which was passed, that is the Limited Liability Partnership Act. And what is all about that all about how do you get yourself incorporated of into a particular LLP? That is what we will be talking. Okay, so as I said, let us begin with first introduction to partnership. So when we talk about Partnership Act, it is partnership is one of the forms of business organization. Those who were there with me yesterday, I think you're very clear with the concept where I said sole proprietor is one form of business where we have one single person who takes care of all the business activities. But when we have two or more persons who come jointly together to carry some business, that is where we say it is the birth of partnership. So when there is partnership, people pool their resources, their money, their material, come forward for a mutual advantage and try to bear that risk of business. So that risk is divided. Partnership is a very voluntary collective, I would say, force where there is as in no compulsion to get a partnership registered. So the concept of partnership is that firm is not an entity or a person in law, but it is just an association of persons. And the firm name is the collective name of for individuals who have agreed upon to do certain kind of business under that partnership firm. Now, when I say that Indian Partnership Act of 1932, that has defined partnership as a relationship between persons who have agreed to share profits of business and to carry on by all or any one of them acting for all. That means either one person is going to represent all the other partners, or all of them are going to be part of the economic activities or part of different business activities, and the purpose for all these things is to earn profit. That is what that line says, to share the profits of the business carried on by all. That means everybody is involved into some kind of business activity related to that partnership firm, or either they have appointed one of the partner as the acting partner and he or she is working on behalf of the remaining partners. So there are three aspects to partnership. If we say we have partners, we have firm, and we have a firm name. Who all are partners? If I say persons who have entered into that partnership with one another are called individually as partners, collectively they are called as a firm, and the name under which they do their business is called as a firm's name. I hope I'm clear till here.
Yes, ma'am.
Yes.
Okay. So when I say what are the essentials of a partnership, see, there are these are very important points to remember. As I said, single person doing a business is a sole proprietor. But when we have more than one person, just excuse me for a minute. Okay, so I was just talking about that when we talk about different types of, different essentials of partnership, it is something what we need to remember is that at least two persons, minimum of two persons are required. They come together to share profits of business. They are, the relationship must arise out of an agreement, what they decide mutually, that on what grounds are they going to carry on the business. The business must be carried by all, or even if any one of them is acting for all, that is also termed or that is also regarded as partnership. And every partner who is part of that partnership firm is liable for the acts of the firm done by a partner. So if supposingly any one of the person has done anything on behalf of all the other partners, remaining all the partners are liable for that particular act. So if I say it is association of two or more persons, now this is what you need to remember, that government what they have done is they have given certain kinds of important things to remember. That is, people those who are competent to enter into a contract can only become partners. What do we mean by this word competency? Competency basically means that a person is mentally and physically fit to do business, even if he or she is physically challenged, but then he or she has to be a sound person. Sound means mentally he is the person who can take rational decisions. He understands what is right or wrong. There is, under the Indian Contract Act of 1872, we have this as capacity of parties, where we talk about the competencies of different people entering into any contract. So partnership is also a contract. So where we say that people should be competent enough, that means they should be fit from their mind to take rational decisions. As I said a few minutes back, that at least two persons are required, otherwise it will not be called as a partnership. Government has prescribed certain rules in partnership, that minimum of 2 and maximum of 50 if it is a private partnership, and if it is where we talk about government, so we have a rule here which says that again minimum of 2, and then you have certain limit as we have in Companies Act. So it is provided that number of persons which are prescribed under subsection shall not exceed 100. So the ceiling under the rules can be varied. Under no circumstances can also go beyond 100. Okay. So I have explained you a concept yesterday where I said about Hindu undivided family, which is called as HUF also. And I said that any particular child who is born in that family, so from the birth he becomes a partner, and the one who is taking all the decision of that partnership firm is called as karta, and he's the one who is basically holding the entire business. So you don't have to turn to the age of majority, that is 18 years and more, but since you are born in a family where already HUF exists, so that gives you a right to become a partner in that firm. Now, it is advised and said that partnership should always have an agreement, and that agreement can be in oral and written form both. When it is in the written form, we call that as a partnership deed. Deed basically means an agreement. Even if it is in the oral form, it is considered to be valid, it is considered to be legal, but then it is preferred by the court of law that partners should have a written agreement, so that if there is any dispute, to have better clarity, you can refer to that partnership deed, and then you can try to clarify certain things related to partners relation and position. All these partnership firms which are formed, they are basically for the purpose to do business. So it is where the activities are on a continuous basis. It should not be for a single one time act what you want to do. It should be for a lawful business which includes trade, occupation, or might be any profession. And it is where we say that continued participation of those people who are involved in that firm or in that business should be there. Every partnership which is formed, the aim is to share profits. Now, how do we decide that the partnership share is decided? So it is basically which depends upon the partnership agreement or deed, which is mutually decided by the partners. It can also be on the basis of the capital what they contribute. It can be on the basis of their knowledge, skill, and ability. It can be on the basis of the area or the time of what the work they contribute. Purely, which where all the partners agree to such kind of proportions in specific sum, that can be decided as the sharing of the profits between the partners. Now, here there's one point to remember, that if you are having a partnership deed, then it is something which is going to be an evidence with you always, which can be referred if there is any dispute between the partners. Not only profits, but also losses of the business are also shared among the partners. Next characteristic of a partnership firm is that it is a mutual agency. I have already underlined that particular those 2 3 sentences, that it is business of partnership which is carried on by all the partners, or it is any one of them acting for all. So even a single person can conduct different affairs of its business, and it can also be that mutually all of them are taking care of certain areas in that business, and they are acting so that they can take care of different roles which are assigned to them in the business. Liability of the partner is jointly and is severely to the third party for all the acts of the firm done while he is a partner. So if you are a member of a partnership firm, then in that case, liability of the partner for acts of the firm is unlimited. So if I talk about partners, private assets can also be used when there is a partnership firm to pay off the firm's debts. Is it clear till here to everyone?
Yes, ma'am. Yes, it is. Thank you.
So, what I have done is I've just given you an introduction about that particular unit of Partnership Act. Wherever I will feel that the network or the connection is going a bit weak, I may switch off my camera. So, please excuse me for that. I'll share the screen again in between when I actually want to see your responses. I stop sharing the screen and I try to get more connect with you. So now the screen is shared again. Let us discuss about different types of partners. When we talk about different partners which are or different types of partners which can be there, so we can have partners by virtue of partnership agreement, that is how it is decided in that partnership deed, and it can also be partners by virtue of holding out. Holding out is basically where out of conduct, when you make people or make the stakeholders believe that he or she is a partner of the firm, that is what we call as by virtue of holding out. It many times happens that when you are having a person who is coming to your office or to your workplace and is operating many things in that office, and your customers, those who visit to your office, they by a virtue of thought, you know take that for granted that that X person or Y person might be a partner in the partnership firm. So that is, you have, by implied way, you have somewhere made them believe that a person is, a partner in that partnership firm. So that is called as by virtue of holding out. Now, there are actual, active, or ostensible partners. Let us talk about them. Active or actual partners are those who are very much involved in the business. They actively participate in the functioning. They act as agent for other partners, and they are into involvement of all the ordinary course of business. In the event of retirement, it must be where you give a public notice so that you make people or the stakeholders understand that because the partner is getting retired, so these are the liabilities of that particular partner for which the other partners are going to be held responsible. Because I have already informed, it is the firm which is held responsible, not the partner at the end. It is unlimited liability. Sleeping or dormant partners are those partners where they invest money in the firm, but they do not participate in the functions. That is why we call them as sleeping partners. Here, when you talk about their liability for the acts of the firm, ceases soon after retirement because they're already sleeping, they're dormant, they're not active. So, such partners have no duties to perform and are entitled to have to access to the book of accounts. If they want, they can always have a check on the accounts of that particular partnership firm. Nominal partners are those partners who are basically involved, neither they invest nor they participate. They are partners because they are only involved for some kind of nominal activity. So they give their name to the business, to the firm as a goodwill. So that the people, those who are getting involved into that partnership firm, they, assume that because of this person who's very influential or who's very, very having a very good repute in the society. So they are those people, those who just give their names to the business or the firm so that it can get good response in that particular industry. So they are not involved in any kind of investments nor participate in any management of the firm. So they require to give public notice also at the time when they are getting separated from the firm. They are also the known as the outsiders. Whereas I would say they're not like the outsiders because they are mostly, such partners are liable to the third parties because of them or because of him only people are investing into XYZ firm. Partners in profit, as you can see, the name itself is suggesting that those people who are only entitled to enjoy profits and they are not liable for any losses, they are called as partners in profit only. These are people, those who have sufficient capital, but they're not ready to take the risk. So they may be admitted to the partnership firm by other partners, but they are only to enjoy the profits and not to bear the losses. So here also, when he continues to be liable to the third party for all the acts of the firm, just like other partners. Agency is one of the very important, I would say, contract which you will be studying, might be in your syllabus. Wherever you have a partnership firm or a partner appoints another sub partner, when he appoints or she appoints his or her sub partner, that is called as sub partners, or they are called as sub partners. So partners agrees to basically share his profit, in the firm with the third person, and that third person is a sub partner appointed by the main partner. So he is called as partner of a partner. That is what a sub partner is. He cannot bind other persons. He cannot participate in partnership business, nor he can check any accounts. He has only one right, that is to share the profits in the property only at the time of winding up. That is when the partnership comes to an end. Holding out or estoppel, I've just explained you that by acts or by words, when you make people believe that he is a partner of the firm, another person takes action on those set of facts, such people are called as the partners as estoppel or holding out. And a person cannot estop, that means he cannot come out from those acts by denying the liabilities what that person has done under the act of that firm. So he or she is now legally binding the partnership. So there is no formal as such partnership agreement, but then because you have made people believe that he or she is a partner to the firm, so for his or her acts also the partners are held responsible. Let me again ask you, I hope I'm clear till what are the different forms of partnership are.
Ma'am, are you able to go through unlimited liability? Were you saying that liability does not extend to a partner who has retired or is not accountable for?
No, actually, what I said, Grace, was when we are
Mm.
talking about unlimited liability in partnership, partners' liability is unlimited in terms that if there is any kind of a loss, so it is not that if I've invested 5 lakhs or 10 lakhs, so my liability is limited only to that amount. Even if I am part of a partnership firm and my partnership firm is into losses, so to overcome to all those losses, I may also, sell off my personal property if required. So my liability is not limited with the capital what I invest. My liability is unlimited liability. Understood?
Understood. Thank you.
Okay. So let us just continue and discuss about position of a minor in a partnership firm. So I'm sharing screen with you. So as you can see, now we will be discussing about minor as a partner. Let us understand who is a major and who is a minor. Minor is a person who is below 18 years of age. Major is a person who is above 18 years of age and he has certain contractual rights. Major is a person who can always be a person who can be considered that he has the competency or he has a capacity to contract. Whereas minors are all those people, those who are below 18 years of age, and in partnership firm, they only enjoy the profit. They are not liable for any kind of losses. So when I say what are the rights of a minor, minor is entitled for all profits, property in that particular firm which is agreed upon. He can have also access and to inspect and copy any of the accounts of the firm. But when you talk about minor being, what are the liabilities of a minor? So liability of that minor is to the extent of his share in the firm. Neither he is personally liable nor his private estate is liable. Like I was just talking about, and I gave you an example that when we talk about my private estate, which I am also liable if I am partner in a partnership firm, That is not the case with a minor. Minor is only one who enjoys profit in the firm. He cannot be declared as insolvent. Who's an insolvent? Can anybody tell me who's an insolvent? Have you heard about this? Anybody who can tell me who's an insolvent? Have you heard about this word before? Insolvency, insolvent. At least say yes or no so that I can come to know. If no, then I'll give you the answer.
No, ma'am.
Okay. So when I talk about an insolvent, insolvent is a person whose liabilities are much more than his or her assets. So when your assets are very negligible and your liabilities have exceeded those assets and you are not in a capacity to pay your debts, then government declare you as a person who is called as insolvent. And the insolvent person is a one who is not competent to contract. So when we talk about capacity of parties, we say that a person, if he or she is declared as insolvent and if he enters into a contract, then in that case it is said he cannot be held liable for any kind of losses. What did I said few minutes back was that minor cannot be declared as insolvent. Why? Because minor is a person who is already below 18 years of age. He is not having as such any of his private property. He will only enjoy the assets of the company. Even if the company goes insolvent, then also the firm's debt cannot be paid out of his property. It is only paid from the firm's property. Now, what happens if the minor attains majority? That means when a minor is of now age of majority. I'll just share the screen so that you can connect with what is written there. Okay, so as you can see that when we talk about position of attaining majority on attaining majority, it says that minor has to choose to become a partner to serve his connection from the firm within 6 months of attaining his majority. So, like suppose if I talk about myself and I say I'm a person who is below 18 years of age and I'm a partner in a firm. Many times it happens that there are existing partners and one of them, he or she loses his or her life and his son or legal heir becomes a partner in that partnership firm where the partners mutually decide to make the son or daughter of that person who has deceived to become his or their legal representative. So in that case, if that person is a minor, then minor will only enjoy profits. But when that person becomes a major, there's certain choice which is given to that person. What is that choice? Within 6 months, he has to decide that whether he wants to continue or whether he is not interested to be a part of now that firm. And if he fails to give such notice, then he will be partnered, considered as a partner after the expiry of the said 6 months. Okay. So where such person become a partner now, after attaining the age of maturity, his rights and liabilities as a minor continue up to the date on which he became a partner. But now he will also become personally liable to the third party since he was admitted to the benefits of the partnership firm. So now he will be sharing in his property, in the profits of the firm. He'll be part of all those things which is now enjoyed by a major in a partnership firm. So where does such person elects if suppose where such persons elects not to become a partner? Suppose you are a person who is a minor and after attaining the age of majority, that is now when you are 18 years of age and you decide I don't want to be a partner in that partnership firm, what can you do? You can go ahead with certain rights and liabilities that is which were of a minor under the section up to the date on which he gives public notice. So if it is some kind of such things happening, just a second, children. Yeah, so I was just talking about that when it is he or she becomes now a major, then he or she can decide whether I want to be part of a partnership firm or not. If suppose he says no, then his share shall not be liable for any acts of the firm after the date of that notice. He shall be entitled to sue the partners also, that is to file a case. Sue means to file a case for his share of profit and profits in the company, property in the company. So he can take all those things and can leave that particular partnership firm. Now, there are certain types of partnerships which are called as partnership as at will and particular partnership. Any questions, any doubts still here? Anyone having any questions, any doubts still here?
No question. Thank you, ma'am.
Are you clear with the bit concept of partnership?
Yes, it's clear, ma'am. Thank you.
Grace, Akim, Vasant, France. I hope you are listening to me.
Yes, ma'am. We are listening.
Yes, yes.
Innocent, Chipulumustu. That is something where I want your involvement, that you should be there, that it keeps my energy also high. Okay, I'll share the screen again and we will be discussing something now ahead to what we have already talked about. So when you talk about all these things, let us come to new thing, that is types of partnership. As I said, there are two types of partnership: partnership at will and partnership which is particular. Indian Act of the Partnership Act of 1932. It has all these things covered under various sections. Section 7 and Section 8 of the 1932 Act talks about partnership at will and particular partnership. Partnership at will basically means that there is no fixed period which has been decided as duration of the partnership, and as in both the partners or three partners or 10 partners, they are till their will, till the time they are determined to take that partnership to a next another level or to a particular period, they can always go ahead with that. Death or retirement of a partner will not affect the existence of such partnership as there is no defined period of termination. So here, partnership can only be dissolved when all the partners agree upon and they give a notice in writing that now we want to terminate the partnership firm. So this is where we call that as will of the people. So firm is only dissolved where the date is mentioned in the notice, not prior when it was formed. Second is particular partnership. This is where basically we form a partnership for a certain period. So when it is for a particular period, for a fixed period, for a particular undertaking, particular adventure, that is called as a particular partnership. Okay. I give you 5 minutes of time. Please read these co-ownership with partnership. How are they, connected? Partnership distinguished from other forms of business. Please read that and then we will discuss. I'm giving you 5 minutes of time and I'll share my screen by that time. I request all of you to please read this so that it becomes easy for you. See, it is co-partnership and partnership, co-ownership and partnership. When we talk about co-ownership and partnership, how are they, other? Like co-ownership is something which is different from the partnership. So if two or more persons own a property jointly and they employ the same property in a business and share profits, that is a co-ownership. That is not a partnership form. Partnership always arises out of a contract. That contract can be either express means either in words or in writing, or it can be implied. That means through oral contracts, what we do, and we are part of that partnership form. Whereas co-ownership is basically which arises from an agreement by the operation of law or from the status of any other way. That is where we have na co-hires of a property. That is what is co-ownership. Partnership is basically where partners are agents of other partners. Co-owner is not the agent of the other co-owner. They are individually as a different unique identities. When you talk about partnership, it involves sharing of profits and losses, whereas co-ownership, it is not necessary that profits and losses will be shared. Partnership cannot transfer, partner cannot transfer their right and interest to anyone without consent of all the partners. But if I am a co-owner of a property, I can always do that even without the consent of others. Person can only ask for share of profits out of property, whereas a co-owner can ask also for division of property. Here, a co-owner is a person who can ask for division, not only the share of the profits. But in partnership, you are only limited to ask the share of the profits of the property. Is it clear?
Yes, ma'am. It's clear.
Please go
Very
through
clear.
this. Yeah, it is academic counseling. Otherwise, law is very, very exhaustive. It will be very difficult for me. All these topics in 1 hour is very difficult to complete. So please read them and let us go on the discussion mode. What I mean to say is when we will be on with the discussion mode, that will make things easy for you. So when I say it is a Hindu joint family, I've just explained you that when we have your HUFs and how are they different from partnership, I said Hindu joint family arises out of a contract where it is basically on the status by birth in the family. The child is born in a family, automatically he becomes a partner. But in partnership, what happens? It is out of contract, not out of birth. So if suppose I am a partner in one of the firm and I have a son or a daughter, so then he or she will not also be a partner in that particular firm. It is something where a proper contract will happen when he or she attains the age of majority. But in HUF, what happens is there is one person who is called as Karta, and in his family, all those those who are born, the boys, those who are born, they are given the status of partners. Partnership is governed by the Partnership Act. For your Hindu joint family, we have a HUF law by the Hindu law. Minor cannot be partners. That is what I have already explained you. And if they are, so they enjoy only the profits and not the losses. Whereas in Hindu joint family, what happens is minor from the birth only. If you are giving that recognition to a person as a partner, that means then he or she, even if he or she is a minor, he is a partner in the firm. Death of a partner does not dissolve the part. If like all the people die, then definitely the partnership will come to an end. But death of a co-parsoner does not declares to the end of the Hindu joint family, because there are other people, other members in the HUF. Partnership, each partner has certain implied authorities, that is to borrow, to bind over other partners. But in Hindu joint family, as I said, only Karta, who is actually the manager, is head of the family and is entitled to do certain kinds of different roles which are of the authoritarian nature. You can just read all these concepts and you will come to know about how are they different from partnership. Now, when I talk about partnership deed, this is very, very important. Deed is basically an agreement where you can have that in oral, you can have that in writing. I've already shared that. If it is in writing, it is very, very important document because it acts as evidence. It acts as onus to prove. So rights, obligations of partners, the kind of capital which they put in, the profit sharing ratio, their duty, responsibility, everything is mentioned in the partnership agreement or a deed, which is properly stamped under the Indian Stamp Act, and the copy of the same must be given to each partner at the time of registration. So, what can be the things which are included in an agreement? It can be firm's name, date on which it is starting. If it is at will, that is partnership at will, or it is a particular partnership, that also needs to be mentioned. Full name and permanent address of all the partners and date when each partner has joined. What is the nature of business, capital, what is involved, what is partners drawing. Drawing means the withdrawal which a single person can do for his or her personal use. Interest on capital, if suppose a person puts in more capital in the partnership firm, so what is the interest on capital which he'll enjoy? What is the status of different loans if he takes on the name of the firm, current account, and so on. So, current salary, commission, and remuneration which are paid to the partners. What about the different maintenance of certain books of accounts? Who can inspect? When can it be inspected and audited? All are these things which are very important and should be mentioned in a partnership deed. Partnership deed also helps you to list down certain rights and duties of partners, even if there is any kind of a conflict. So there should be arbitration clause so that the disputes can be settled. If there is any kind of a valuation needs to be done of a goodwill on case of retirement or death, so how it is going to be done, in which manner it is going to be done, that is also something which is a content of your partnership firm. I ask my question again to all my dear academic learners. I hope till here what we have done is clear to you.
Yes, ma'am.
Fine, then we'll continue with another topic, that is registration of partnership. When you talk about registration of partnership, it is very important that at the time of application, let me share the screen so that it becomes easy for you to connect. I know all of you are writing your names in the attendance, the message box, which is going to be considered as your attendance. So that's good. Law in itself is a very, very exhaustive subject, and it is really very difficult. I would say that in an hour's time, I'll say that the entire partnership act is clear to you. It is not possible, my dear academic learners, because there is too much of content, too much of legal things what you study, so many different topics which we discuss, and it is somewhere that we need to understand that only thorough revision, reading the concepts, that is going to make the concept easy and things comfortable for you. So please understand that even if I am taking an academic counseling with you, you have to study the entire content once, twice, thrice, and that too on a regular basis after the academic counseling. Yesterday also I said that when we are just a second, children, just a second, my dear learner. Yeah, so I was just talking about that yesterday also we have discussed about the same thing. I can see that the network is going a bit poor, so I might switch off the camera in between if required. And if it is okay, then we'll continue in the same manner. So please read those contents, and make yourself very comfortable with the various concepts of law. I understand truly that it is not that you will be able to grasp all those concepts which are there, but definitely if you are going to revise that slowly, you are going to do very good in this subject. That I can ensure you. Law is something which can be learned by writing the concepts. So develop a habit of writing different acts. Grace, you want to say something? Grace? Fine. So what we do is let us move on to few more topics of partnership because it is already time and I need to start with then company as well. So when you talk about now partnership registration, as I was just talking about, it's important to inform the registrar. It is very important to mention in a proper prescribed form certain important things about the partnership form, and there is a certain fee which is imposed when you go for registration. What are those important things? They are name of the firm, place of principal, place of business, what is going to be the principal place, then name of any other place where the business is going to be carried upon, date when each partner is going to join, their address, their duration. These are all those things which are mentioned at the time of registration. Now, what happens if you do not register the partnership firm? If there is a non-registration, I cannot mute or unmute my mic. Is it something on the admin side or its computer? Just give me a minute, Grace. I'll just check. Uh, Dear learners, is Grace still there in the academic meeting? I cannot find her. I think she's not there. She was having some concern. She was not able to unmute herself. Suleiman, you want to say something?
I think that yes, it's trying to recover the mind.
Suleiman, I request you to please write that in the chat box. There's too much of noise coming from your side. I cannot find her still. I think she's not there. Let me share that screen and we'll start. As she joins, any one of you can just tell me so that I can just see what is the difficulty she's having. So, now talking about another part, that is, we were talking about what are the effects of non registration. So, if you do not register the firm, very big disadvantages that you cannot sue. Sue means you cannot file a case when there is any dissolution of firm happening, when there is any kind of accounts to be settled, when you need to realize the property, when any claim needs to be set off, when there is any kind of a proceedings or in the execution or any other proceedings to be made. So because you don't have any evidence, you do not have any onus to prove, firm cannot institute a sue against a third party. Firm cannot sue, but it can always be sued. Third party can sue the firm. But what is important is that if you have a registration of the firm, partners of the firm can also sue each other. That if there is anything which is conferred against the Partnership Act, so that can be done. So now there's a small activity, you can read that later. I'll just quickly come to rights of partners. Again, requesting you to please go through these rights very quickly in 5 minutes of time, and I'll discuss with you. I think I've stopped the screen. Just a second. I request you to please go through. Grace, you have joined. Grace, you are having some difficulty, right? You said. Uh, Now you try, Grace. I have done some changes. Try that again, Grace. Okay, so there's a problem from your side, Grace. No issues. You can write that to me in the chat box and I'm going to read your concern from there. Don't worry. Okay. I was just saying that we are left with rights and duties of partnership. I'm just sharing that slide with you. Please go through that so that we can have a discussion in another 5 minutes. Can we have a discussion now? Have you read some part of it? My dear learners, can we have a discussion on it? Can anybody tell me what are the rights of partners? Come on, give a try. Come on. Very easy points which are mentioned there. My dear learners, have you read what I have shared with you? See, otherwise it will become very difficult. Law is something where you have to participate. I'll not come to know whether you are understanding or not. That's the reason I'm asking you. Have you read those points of rights of partners in a partnership firm? Grace, please write that in the chat box. Even others also. Akim, Farida, Khamis Mohammed, Baura, France, requesting you to please write that in the chat box. Salihu,
Yeah, can you please reshare the screen?
Khamis, write that in the chat box. I'm asking you to please write that in the chat box, whatever is your concern. Let's have a proper academic counseling. It is two-way communication which I would like to have with you. Whatever is the concern, write it down. Whatever you have read till now regarding rights of partners, please write that in the chat box. Come on, I'm waiting. Okay, so you have asked me to share the screen again. What about others? I'm sharing the screen again. Can I have answers, please? My dear learners, I request you to please write that in the chat box.
Okay, ma'am.
Okay, so I am continuing with the topic. If you are not interested for two-way communication, I cannot waste my time. I'll be moving ahead very quickly because one-way communication is not going to serve the entire essence of your academic counseling. I've been telling you My question is that I've asked you to read rights of partners. I've already shared that content twice with you. I really don't know what is going wrong, but this group, why I don't know that you're not responding. You've already been with me in one of the academic counselings.
Let me try,
Can
ma'am.
all of you just switch on your cameras and let me see where are you all? Are you really listening to me?
Yes.
Switch on your cameras. Okay. Now the question comes again. When I'm sharing the content with you, why are you not responding? See, now I can
Because,
see that smile at least. It is
ma'am,
very difficult otherwise. One way communication on one side, and I really don't know what my learners are doing. Yes, Asad?
right of partners, this need time, really need time to understand first, and we will find the question mark area. So this is a problem because the content is
Asad, you're not clearly audible to me. Can you please write that in the chat box?
okay.
See, okay, right to book records, right to legal representation, right to benefits, profit, right to decision. See, when we are talking about rights of partners, I really want you to understand that in normal course, every partner has certain rights. That is, he can enjoy that right of being a partner and have a right to take part in all the conducts and management of business. He has a partner, as a partner, he has a right to express his opinion. As a partner, he has a right to always inspect the books of accounts. He can always, whenever he wants, can do the scrutiny. As a partner, he has a right of legal hire representatives. That means his or her legal representatives can be given the responsibility if he or she loses his or her life. Deceased partner means a person who loses his life shall give a right to access and to inspect any copy. So, if, like, suppose we talk about Mr. X, who is a partner in a partnership firm, and he loses his or her life, the legal hire of Mr. X can always ask the remaining other partners that he wants to inspect and check the accounts of that particular partnership firm. That is also a right of partner. Right to share profit, I think all of you know, it is always mutually decided. It is purely on the, I would say, in the hands of the partners. How do they go ahead for dividing the profit? It depends upon work, it depends upon capital, it depends upon various things. That if supposingly a partner is taking certain kind of, like money, if he has put there, so he can always demand for interest also. So if he has put any contribution beyond which is the amount of the capital which is agreed upon by the partners, so he can always enjoy the interest on that particular money advance which he gives to the partnership firm. And also for all the business in the capital which he puts in, he can also enjoy the interest on capital. So there are certain now term vocabularies which I will be talking about. That is right to be indemnified. Indemnified means that if there is any kind of in the ordinary or the proper conduct of business, where all the payments made by him in respect of partnership debts or liabilities and disbursements, in case of any emergency, for protecting the firm's losses or maybe any kind of a payment or liability, then in that case it is a person, that is a prudent man, would make incur or perform in his own case under similar circumstances. So you can always ask for that indemnifying. That means you can ask for that loss which has happened. You can claim for those losses. That is indemnifying by the firm for all expenses incurred by him. Like, suppose I take an example. I'm a partner in a partnership firm, and for my firm, I have done or incurred certain expenses or I have spent certain amount of money. So in the proper conduct of business, I can always demand for that particular expenditure which I have done for my company, for my firm. That is to be right to be indemnified. So I will be treated as a separate person, where if I spent more than what was my responsibility or duty, so I can always ask for that reimbursements to be done to me. Now, there are certain rights which are rights of partners, which we call that as in special circumstances. Uh, Grace, you are back. Good to see that. Sad, you write the area talks about detailed partner mutual rights that involved in a particular business. Yes, right to be consulted also. Yes, Suleiman, I completely agree to what you have written. So this is basically, for you to understand that partners in a partnership firm, they have so many rights. They can always have a right which they can enjoy in emergency. That is, they can act in emergencies. If they want to protect the firm from any loss, so they can take certain actions, and that is their right. No person, no partner can put a question against them that why have you done that. Why? Because he has done something in emergency to protect the firm. He always have a right to prevent admission of a new partner. New partner is always admitted with the consent of all partners. So if a person feels that I am not, ready to admit a partner in my firm, and he has any kind of dissentments, so he can also stop the admission of a partner. Right to retire says if a partner is retiring with consent of all the partners, he can always give that notice prior, if it is partnership at will, that I am retiring from the business. That is also his or her right. Will is something which is decided mutually. That is why I've said right against, in case of will. Right to continue as a partner, every partner has a right. Now, that particular right to continue in the partnership, he cannot be expelled from that firm by any majority of the partner. So if he is a partner, he will remain in that particular partnership because it is his or her right to be a partner. And right of an outgoing partner is always that he can use the firm's name, subject to certain conditions, represent himself as carrying on business of the firm, can also solicit persons where he is dealing with the firm, or before he has to be seized as a partner. Seized means to stop, called as a partner. Now, this was all about rights. Now, when we talk about duties, these duties are also, which are like, is responsibilities of a partner. So, duties can be in the form where we say that duty is of good faith, that is to carry on the business to greatest advantage of the firm, duty to indemnify for any loss which is caused by a fraud. So, if a partner is bound to indemnify where he enjoys that as a right, so he has a duty to indemnify the firm for any loss because it is caused because of his or her fraud or maybe his conduct in that particular business. So duty is also to take proper use of property. Duty is to due diligence. That means that every partner is bound to attend diligently to the business of the firm, and in absence of any agreement to the contrary, he is not entitled to receive any remuneration. These are all duties and responsibilities, I would say. You can just go through them and read this part, as we are having less time and we have two major laws to be completed. I will be talking now something about company. Requesting you again that please go through the Partnership Act. It is very, very exhaustive, but yes, definitely on the other hand, it is very interesting if you are going to take, give some interest in reading the entire content. In another 30 minutes, what we'll do is I will be talking about Companies Act. See, Companies Act of 2013, let me share the screen. It rhymes so well. Companies Act of 2013, let me share my screen. So when I say Companies Act of 2013, is the screen visible to all of you?
Yes, it is.
Yes, it is.
Let us talk about the beginning or the formation of the company. 1956 is the act of company formation, but the Companies Act 2013 is where we talk about the amendments which have happened and the latest act which we are referring. Basically, when we talk about the Companies Act, usually nowadays we refer to the Act of 2013. Total, there are 29 chapters, 470 sections, and 7 schedules. And it is basically in this where we talk about different types of, applicabilities of Companies Act 2013. So, company incorporated under this act or under any provision for previous company law is liable for to be falling under Companies Act of 2013. We have insurance companies, we have banking companies, we have companies which are engaged in generation or supply of electricity. We have such companies which are body corporates and are incorporated by any act for time being in force, and the central government by notification on their behalf has declared that particular corporation as a company, so they are also considered to be a part of company. As I said, company, now when we talk about formation of a company, same like what we talked about in a partnership firm. Here also we have two or more people, but yes, definitely the limit of people here in case of a private and a public company we will be discussing, because when we talk about private company, the number required is 7, and in case of a public company, it is where we say, sorry, in case of public company, it is 7, and 2 in case of a private company. So that is something which is to be remembered from your side. And when we talk about how it is formed, so we say company is an artificial, invisible, intangible, existing only in the contemplation of law, as in we cannot see, we cannot touch, we cannot like I would say talk to a person in person, because it is an artificial being, it is invisible, it is intangible, but then it is only under the eyes, its existence is only under the eyes of contemplation of law. So this is what basically company is. It is an incorporated association which is an artificial person which is created by law, which has a separate legal entity and has a perpetual succession in a common seal. Remember these lines, these words, what I have said. I repeat again, it is an incorporated association, it is an artificial person created by law, having a separate entity, a perpetual succession, and a common seal. Common seal is basically signature of the company. Perpetual succession means even if shareholders come and go, the company's existence will be there. Perpetual succession. So it is going to have its own existence. It is a separate entity, so it has no kind of the I would say limitations to its members. Even if all the shareholders in a company they die, still what happens, the company as a separate legal entity will exist. Now, when we talk about certain features of a company, we say it is an incorporated association. I've already explained you. So it has a mandatory to be in the form of Companies Act. We have public and private companies. It has a separate legal entity. We have a perpetual succession. This is that point which I was just talking about, that its member may come and go, but the company goes forever. So even if there is death, even if there is insolvency, even if there is retirement, member leaves the company, but the company is unaffected. That is what is a perpetual succession means. Limited liability. Here we mean member of the company in case of liquidation or winding up of the company cannot be called upon to contribute more than that has been agreed. So liability of a member depends upon the kind of company which he is a member and the number of shares he has purchased for that particular company. This case was not there in case of partnership. However, if it is unlimited company, then liability of its member is unlimited as well. Otherwise, the shareholders' liability is limited to the amount of shares what they have purchased of that company. Company is an artificial person, as I just said. It is created by law. It is clothed with all the rights of an individual, being subject to certain duties. But if I talk about existence as a person, so it is invisible, intangible, and it is only under the contemplation of law. Company has a common seal. As I said, it is an artificial person, so as to authorize certain documents or to give certain kind of legal acceptance in Companies Act, we have a common seal which is covered under Section 9, where it takes considers the company's signature that yes, it is approved, and a company secretary is basically appointed where the company directors or company secretary using the common seal can give the consent for the same. Transferability of shares also in a company, we say that shares can all, here are the movable property. You might have heard about it in different share markets that, just a second. Okay, I thought somebody has messaged. So as I was just talking about that you might have heard about that many of the times what do we hear that people buy company share then they sell company shares. That is why we say that they are movable, properties and can be transferred from one person to the other. The objective behind this is that we do not want to restrict the right of transfers. So that is
Doctor,
why you can always purchase and you can always sell the shares. Yes.
what does mean artificial person?
Artificial means it is not a real person. Physically, you cannot say that Mr. X is a company, Mr. Y is a company. It's an artificial person. In reality, it does not exist. It is just the name of the company is there, which is considered as a legal identity or a legal existence of a company. That is what do we mean by artificial person. Asad, am I clear?
Yes, it's clear.
Okay.
Thanks.
Is there any difference between limited liability company partnership?
Kamis, please write that in the chat box. I repeat
All right.
again, from your side, many times it happens that because of poor network, audibility is not that clear. So I'm requesting you to please write that in the chat box. I'm waiting for your question. Kamis, I'm waiting for your question. Please tell what is the difference between partnership and limited liability company and its legality. Okay. See, partnership and LLP, it is not limited liability company, it is limited liability partnership. Now, limited liability of partnership is an act of 2008 and it differs from company because when we talk about company, it is more about, we say that it has a legal, like it's an artificial person. LLP is where you have partners, you have people, but their liability is limited to the number of shares or to the number of capital what they invest in that partnership firm. Firms, it is not that it is the unlimited liability what we used to have in case of your normal partnership firm. Partnership firm may in partnership firm, it is where they have, even if a partner is there in a partnership firm and firm has certain liability debts to pay to the creditors, so even the personal property of the partners is used to dispose of the debts of that partnership firm. But in LLP, it is not that case. Third party Asad basically means here we are talking about that when you are into any kind of different, I would say, business activities or business different types of roles. There are many times when you have different people involved into the companies or maybe in your partnership firm. So it can be third party involvement which is said. Now, usually, which context are you asking, Asad? Can you just Clarify that to me. You want to know that in terms of partnership or in terms of company? Asad? Asad
In
Mustafa,
terms,
please. Yeah,
in
please
terms
rise.
of company.
Company. In company, when we talk about and we say that there is a third party, it is basically we call them like, see, in company what happens is we have various shareholders. They are those who are the owners of the company. They are the one those who invest in the company. So they are the ones those who are basically the people those who are responsible for the entire functioning. We have board of directors. Company is, if the company is going to swim, the shareholders are also going to swim. If the company is going to sink, that means it is into losses, so shareholders are also going to be in losses. But that is not the case with the debenture holders. Debenture holders are very different. They are those who are also called as the creditors. So when we talk about creditors, as we pay creditors always first, similarly, if you have shareholders and debenture holders, you will always be paying debenture holders first, and then after, if you are left with profit, you will pay that to the shareholders. Is it clear?
Yeah, now clear.
So here, when you're talking about third party, we are talking about all those people who are not directly, but they're indirectly associated with that company. So let us move ahead. And when you talk about on the basis of various, I would say, areas, how can you divide the company or classify the company? Let me just share that screen so that it becomes easy for you. Khamis, you have asked a very good question that if a company fails to pay its obligation, that is certain taxes to the government, who will now the government hold responsible? Definitely, as I said, that company is an artificial person. I said it is a separate legal entity. It is run by board of directors and by shareholders. So it is basically the shareholders and the directors' responsibility, the founders of the company. We have promoters, those who come up with various ideas. We have different directors, as we have studied in partnership also. Here also we have different directors, those who are the acting persons in a company, those who take charge of all these legal obligations to be paid. So if there is any kind of a default which happens, it is I would say a kind of fine or a penalty which will come on a company, and the loss is going to be taken care by all the shareholders or by the directors of that company. I'll just continue further. Now, because I think there is some network issue, I'm just switching off my camera. Okay. I hope the screen is visible to all of you. See, we can also always have, on the basis of liability, company which is limited by shares, or company which is limited by guarantee, and unlimited company. When I say limited by shares, it is always okay. Before, let me explain you what is MOA and AOA. See, memorandum of association is a document which basically is a very internal document of the company, and it is not shared with everyone, that is in public. Article of association is again a very important document, but that document is shared in public, telling about the number of shares which the shareholders or the people can invest in, the amount, the price, basic small details related to it. So when I say it is something which is mentioned in the memorandum of association, so that is which is the internal document, and if it is mentioned in that the members' liability is limited to certain extent, then they have to follow that particular thing. That is company limited by shares. Company limited by guarantee means where the liability of the member is limited by the memorandum to such amount as the members may respectively undertake by memorandum to contribute to the assets. That means they take a guarantee that even if there is any kind of a loss, or there is any kind of, there are no working funds, still they are going to, by any kind of donations or endowments or fees or charges, they are going to raise the funds and they are going to pay the debts, because company is limited by certain guarantee. Unlimited companies are where we say that the member liability is unlimited. Now, here what happens is liability of the member ceases when he ceases to be a member. That means till the time he is a member of the company, that is, he is a shareholder, his or her liability is unlimited. So, liability of each member extends to the whole amount of company debts. That means even if he has purchased or she has purchased less number of shares, but if it is an unlimited company, your personal property is also going to be a part of, at that time when the debts have to be disposed of. So that is, he will not be entitled to claim from the other contributions from the other members. Okay. Now, let me move on to, on the basis of members, we can have one member company or one person company, which is called as OPC. This is a new term which is introduced in 2013 Act, which says that even one single person can form a company and it can be run where, we used to have it in a sole proprietorship. But here, what is going to be the difference? Sole proprietorship is always, here you will be having a separate legal entity. So sole proprietor is not having any separate legal entity. He is a person whose liability or his legal entity is his own. But if it is a company, then it has a separate legal entity with a limited liability of a member, that is the concerned person, one single person who is forming that particular company. Private company, I've just explained you, which has a minimum paid up share of capital. It has, basically, the important thing is private company has a restriction that the rights to transfer its shares, so the rights of the private company cannot be transferred. It prohibits any invitation to the public. It is only a few people, those who form that particular company, and they are the ones who have certain kinds of rights rather than the rights which they enjoy, which is given to the people in public. We have small companies, we have big companies. Small companies are basically, again, small is where the paid up capital is not more than 50 lakhs. And here it is very important to remark that for the capital which we are not exceeding to 50 lakhs, or maybe to the higher amount, if suppose it is mentioned in the MOA that it can go up to 10 crore rupees, so that can also be as part of that. Public company is basically where we talk about that it is not a private company, and the minimum paid up share capital, if they have a minimum paid up share capital, that means share can be called for 10 rupees, 20 rupees, 30 rupees, and then it is divided into different callings. I don't know how many of you have studied companies before, Company Act before. When we put any kind of a company share and I want to sell that, we have different ways of calling that share price. We call that at the time of application, then allotment, then first call, second call, final call is made, and then finally company tries to get the money, what is the share price of the company. So that is also one important thing which you should know. Please read this part, that is what are the different types of company, because I would like to go ahead to something which is apart from meaning and types of company, that is MOA and AOA. I just said memorandum of association is one of the very important document. It regulates companies' external affairs and it complements the articles of association. It is a very important document referred as constitution or charter of the company. Mark my words, it is referred as charter of the company. Very foundation on which the whole company is existing. It is can be reviewed from the memorandum of association. We have table A to table E in MOA, and you can just go through what are those 5 tables. Contents of MOA basically are having name clause, that is what is the name of the company, where is the registered office, what is the liability of the company, capital clause of the company, certain few important things which includes the association with several persons, so their name, their details, against their name is mentioned, certain conditions, that is what is called as associations. AOA, as I was just talking, it is a supplementary document of MOA which deals with the exclusively with rules and regulations of the internal management of the company. So articles or rules are commonly known as by laws of the company. So they are subordinate to memorandums, but then it is something which is very, very important document. It helps you to understand that what is the rule or regulation which is mentioned in that particular AOA, which needs to be referred by the members or the shareholders of the company. Let me stop here for today and ask you, are you able to understand the concept till now what we have done? Yes, shares of the company can be transferred, but not in every regard. As I said, private company you cannot transfer. Public company, we definitely do that in the share market. I think you might have observed that many times we sell number of shares, we buy, we sell shares. Have you observed that?
Yes, ma'am.
Yeah. That is what we do. So that is always transferable. My dear learners, I request you to please go through this part of your chapter, that is company, and let us discuss that tomorrow again, because I understand that it is very exhaustive otherwise to understand and remember so much of law, right? So please go through it, and tomorrow when we start with the academic counseling, I'll quickly brush up company again, and then we will move on with the next topic in the third module. Is it okay?
Yes, it's okay, ma'am.
Otherwise, it will be very heavy. So
Definitely.
I would like to officially thank all of you for your patient listening. Thank you so much for being there and giving the answers in a very attentive manner. And I hope to have that participation in the coming academic counseling with you. So it's a request. Again and again, I say, please, my dear academic learners, read the content and come so that we can have a two-way counseling which can happen. Otherwise, in an hour or so, we cannot complete the content for the entire block. It is not teaching which is basically happening, it is counseling. So I'm here to help you. I'm here to set up the base. Okay? Yeah. It is really involving module. We will try again. You have to grace. Okay. So I think we can end the class here for today, and we will be meeting tomorrow again with some part of company and with your third block.
All right.
Thank you once again.
Thank you very much.